important ones that you need to practice with. The other thing I wanted to mention is that there are some books that the consortium suggests as good books for you to review, to study before you take your examination. So I'm going to give you the link. These books, you can buy them at this link, www.americanbar.org. That's for the American Bar Association. And if you go there and in the search, you can type the title of the books. The books are basically 3 small books. This is volume number 1. Okay, so this is volume number 1. Okay, and this is volume number 2. I'm going to show you now volume number 2. This is volume number 2. And this is volume number 3. These are the 3 books that the consortium suggests you purchase from the American Bar Association to be better prepared for their exam. To purchase those books, again, you go to the www.americanbar.org, and in the search, type the following name, Law and the Courts, which is basically the name of the books. Law and the Courts, and then you search for that book. And when you search it, you're going to find different options here. You can see that at the bottom here, there's one that says Law and the Courts Volume 2. Okay, well, there's Volume 1, Volume 2, and Volume 3. I'm sure that you can find Volume 3 as well. The most important one really is Volume 2. Volume 2 is the most important one. So let's just click on that one. And you can order it. It's only $2.50. And it tells you that you can also order Part 1 or Volume 1 if you like. And I'm sure you're going to be able to find Volume 3. So you see right here at the bottom, it says Law and the Courts, Volume 3, Juries. Of all these 3 books, Volume 1, 2, and 3, Volume 2 is by far the most important one. I will say that you should spend, the probability of getting something like that in your exam is 85% for Volume 2, 10% Volume 1, and 5% Volume 3. So you need to study those books. There are not too many pages. And he basically talks about what an opening statement is, what direct examination is, what a verdict is. And then he gives you a very interesting list of a glossary list, which will be in addition to the glossary list that I provided you in the course, in the lecture that corresponds to a legal vocabulary particularly. So it is a very, very important book. So once again, Law and the Courts, Volume 2, Court Procedures, you should order that as soon as you can. Okay, so that ends. So then let us begin with the course. Then the first lecture, lecture number 1. Okay. Okay. So what's going to be in your written state exam? Let's just look at what's going to be in the first section of your written state exam. There is what they call general language proficiency. Section, and in that particular section of the exam you have sentence completion, then synonyms in context, synonyms and antonyms basically, and then the second part of the exam is idioms, and then the third part of the exam is court-related terms and usage and professional conduct. What that means is court-related terms and usage, like for example what's arraignment, or what is a concurrent sentence, or what's a simultaneous sentence. There are all multiple choice. And then there's also the ethics of the interpreter that gives you different scenarios and questions that basically they ask you what will be the best course of action, or what is the interpreter supposed to do if the interpreter is faced with this particular scenario. All this will be discussed in our 4-lecture course. Each lecture emphasizes different thing. This lecture, for example, covers sentence completion and court-related terms and usage. So it takes sentence completion first, and then it talks about court-related terms and usage. And we will briefly talk about synonyms and antonyms and synonyms in context. Okay? Now, let's take a look at what a sentence completion is and chord-related terms. What's a typical example of a sentence completion? Well, you can have, for example, a sentence that is as follows. A convicted felon who served part of his sentence in state prison may request blank after completing a portion of his sentence. And that you have to decide whether it is probation, parole, release on OR, or a reduction of his original sentence. Basically, this particular section of the exam covers a lot of material that we discuss in the Criminal 1 and Criminal 2 courses. Not necessarily the translation of terms, but which proceeding comes first, what is probation, what is parole, and so on and so forth. It's pretty simple in terms of for you, because you have already finished Criminal 1 and Criminal 2, and you already know how the system actually works. In this case, for example, of course, parole is the right translation. You will see that it's not too complex. In this book, volume number 2, Law and the Courts, you will get some additional information. So most of the questions that are going to be, you will find in the sentence completion, are related to the explanation of proceedings in Criminal 1 and 2, and the explanation I gave you, plus the explanations that are in the manual. In Criminal 1 particularly, there are some explanations as to what is an arraignment, what's a pretrial hearing, what's a preliminary hearing. And it also includes the material in the book that I just mentioned earlier called Law and the Court, volume number 2. So how do you prepare for it? Well, you should know most of this, but I think by reading this book, you should be ready for it, which is Law and the Courts, volume number 2. It's called Court Procedures. They also ask you questions that have to do with the sequence of events in a court of law. They call that court-related terms and usage. For example, they tell you which one is the correct sequence, as you see here. Is it that sentencing comes first before trial? And so that obviously doesn't make any sense. So once again, what you studied in Criminal 1, in fact, the Criminal 1 book gives you the whole sequence. Arraignment, pretrial hearing, preliminary hearing, pretrial hearing, then a trial, then sentencing. Okay, so this is important for you to keep in mind. And they combine them in various different ways. They may, for example, have something like this, options that really make absolutely no sense. Probation, comma, arraignment, comma, that's not the right sequence. You can't get probation before you get arraigned. You may have, for example, like sentencing, comma, trial, that's not the right sequence either. So what the technique to deal with this particular section of the exam is to check the sequence. Like, okay, here the first one is sentencing, trial. No, that's not possible. You have sentencing comes after trial. Then trial, sentencing, that sounds correct up to this point, but preliminary hearing, no, preliminary hearing comes way before. So that's already out. Arraignment, sentencing, trial. No, you can't have sentencing and trial first. So by definition, the only possibility is letter D, which is arraignment, preliminary hearing, trial, and sentencing, and that's the correct answer. It's important that you, in your mind, you know what the sequence of events are in the court of law. And again, this book, which is Law and the Courts, Volume 2, will provide you with more than sufficient information to determine that. But what's very, very helpful is what we have been discussing, what I discussed in class in Criminal 1 and 2, and what it is in your Criminal 1 manual, where it talks about the definition of what an arraignment is, what a pretrial hearing is, what preliminary hearing. Usually the material that I told you, you don't need to study that for the midterm or the final exam, except that it may come out as extra credit. That definition, you don't need to know how to interpret that, but you need to understand the English portion. What is the meaning of each of those proceedings? So there are a couple of things that we need to discuss here, because they are more commonly used in most interpreting exams, and this is the idea of a consecutive versus a concurrent sentence. They give you questions that are somehow related to these two. When you talk about, say for example, that somebody is charged in count 1 with a crime that carries a punishment of 6 months. So he's convicted to 6 months in county jail for count 1. And for count 2, he's convicted to, let's say, 3 months. And for count 3, he's convicted to 1 month in county jail. The question is, how many months is this person going to be in jail? And the answer to that question depends on whether the sentence is consecutive or concurrent. If it is concurrent, it means that 1 day served in jail counts for all 3 counts. So if you have 6 months for count 1, 3 for count 2, and 1 month for count 3, 1 day counts for the 6 months, the same day counts for the 3 months, and the same day counts for the 1 month. So technically, the time that the defendant will be in jail for a concurrent sentence is always equivalent to the maximum punishment or the maximum time assigned for a given count. So here we have 6 for count 1, 3 for count 2, 1 for count 3. Which one is the maximum of the 3? 6 months. So if the sentence is concurrent, the defendant will serve 6 months and he will cover all 3 counts. On the other hand, if the sentence is consecutive, then that means that the defendant has to serve 6 months first for count 1. 1 day counts only for 1 count, not for all 3. So the defendant serves 6 months in count 1. Finishes that, then the defendant has to start serving now the 3 months for count 2. Finish with that, then the defendant serves the last month for count 3. So in a consecutive sentence, the time that the defendant will be in jail or will be in prison will be added. In other words, count 1 6 months, plus count 2 3 months, plus count 3 1 month. So it's 10 months. Okay? That is if the sentence is served consecutively. But if it is concurrent, the maximum punishment is the answer for the question, because that covers every other count. All right? That's important. You need to know this. Okay? The other important one is, what does it mean when something is done without prejudice or with prejudice? It's very, very simple. And you can see this in the material that you downloaded for this lecture. Without prejudice means that there is a right to a new trial. If I dismiss a case without prejudice, it means I can file another trial regarding this case again. But if I say with prejudice, it means no right for a new trial. So if I dismiss a case with prejudice, no trial. That's the end. That's what it means. Okay? Constitutional rights, it's important to keep in mind that constitutional rights are always waived or given up by the defendant before they enter a plea of guilty. If you enter a not guilty plea, it means you're going to have all these rights. You're going to be able to exercise all these rights. Because if you are not guilty, then eventually there has to be a trial. People will come in to testify against you. You'll have the opportunity to cross-examine them. You will also have the opportunity to actually call your own witnesses to testify. You have the opportunity of hearing what they're saying, both witnesses the witnesses testifying on your behalf or testifying for the other party. So you do exercise your constitutional rights when you go to trial. But if you enter a guilty plea before you go to trial, by definition, when you enter a guilty plea, it means that you have accepted an offer, which generally takes place in a pre-trial hearing, as we studied in Criminal 1. So if you like the offer and you enter a guilty plea or even no contest, they're pretty much the same, then that means there is no trial. And if there is no trial, then you will not be able to exercise those rights, those constitutional rights. So before the judge can accept your guilty plea, the judge has to make sure that you waive and give up your constitutional rights. Why? Because if you say you're guilty today, you're going to be sentenced. There will be no trial. So you have to clearly tell the judge, I don't want to exercise those rights. I'm okay with the offer. I don't want a trial, and therefore I don't want to exercise those rights. So the judge has to put that on the record, and the way you say that is you give up each of the individual rights. So remember, constitutional rights are always given up or waived, pretty much the same thing, by the defendant before they enter a guilty plea or no contest plea. Now, sometimes they want to know whether you understand what are the different elements of an arraignment, what happens in an arraignment. So there might be questions regarding that. And basically, it's pretty straightforward. During the arraignment, the judge advises the defendant of the charges. That's the first step. Usually, they make sure that the right person is in the courtroom, right? But legally, the steps are, the judge has to advise the defendant of the charges, because the defendant doesn't even know why the defendant was arrested. And the arraignment has to take within 48 hours from the time of the arrest. And 48 hours is counted as court days, not weekends. If the court is closed, then it doesn't count. So if you get arrested on Friday, doesn't mean you're going to be seen by the judge on Sunday or even Monday. It could be up to Tuesday, okay? So the first step is the judge advises the defendant of the charges, then the judge sets the amount of bail, if any, and then sets the date for the next appearance or the next hearing. That's what the judge does. And then the defendant enters either a guilty or not guilty or no contest plea. Generally, in an arraignment, the defendant will enter a not guilty plea. Why? Because there's no evidence. So why would you say you're guilty if you don't even know if they have evidence against you? So it's very common that the plea will be not guilty. Almost always. 99.99999%. It's like those DNA results. There are almost always is not guilty. Okay? Unless the defendant doesn't have an attorney and the judge basically, it's not a very serious crime. And sometimes the judge may say, look, sir, if you enter a guilty plea today, this is what you're going to get. So, you can simplify matters. But it's not a good idea. That's usually when there is no attorney. When there is an attorney, the attorneys have to make sure that there is evidence. But usually when the person represents himself, like when you go to traffic court, you don't have an attorney, obviously. So, they basically say, if you plead guilty, you pay this fine. But you may want to know whether there is some evidence against you or whether what the police officer has to say. But for you to be able to know that, you need to go to trial. So it's rare, but it does occur that in some arraignments, those defendants that appear without an attorney will enter a guilty plea. And usually it is, I guess it's the judge pushes the defendant to enter a guilty plea so that the judge can get rid of that case and it's no longer in his or her calendar. Then the idea of an affirmative defense, what is it? This is a defense presented by the attorney for the defendant based on the merits of the case. And a typical example is, what's the merits of the case? Well, if it's the wrong person, if the defendant is charged with the crime when the defendant was not even around, maybe the defendant was in jail already for something else, or in a hospital, or out of the country. That affirmative defense is usually introduced during the preliminary hearing, and it is introduced by the attorney for the defendant. It happens rarely, but there are times that an affirmative defense is in order. If, for example, the attorney for the defendant has evidence indicating that the defendant was out of the country, then that might be a good place to submit an affirmative defense. Or maybe that the defendant was in jail. And that's a good place to present that type of defense. But what it really is the type of defense presented by the attorney for the defendant based on the merits of the case. There are no merits because you're charging the wrong person. Okay, so that's something to keep in mind. Now, a couple of things about this section. You're going to be doing sentence completion based on context in this section in lecture 1. And that will have a lot to do with what we have been discussing. Basically, you complete the sentence based on knowledge of legal proceedings, both criminal and civil, but mainly criminal. And again, what you studied in Criminal 1, Criminal 2, what I discuss in class, what I just mentioned here, and this book, Law and the Courts, Volume 2, that should be more than sufficient. But in this lecture 1, you're also asked to take quizzes on antonyms and synonyms. And that's why you were able to download a list of words with the corresponding synonym. And you're supposed to actually find out, determine in your head or write it down what will be the antonym for that word. Those are high probability words. I cannot emphasize that enough. You need to know those. How do you study? Is there anything that I can tell you that will help you in the exam? Not really, except to study the terms. When it comes to vocabulary, it's either you know it or you don't know it. You can't figure it out. There might be techniques with vocabulary words that come from Latin, where you can look at the root and try to match. But in the consortium exam, there isn't anything like that. It's not like a GRE level, very for graduate school. It's much more straightforward. But these are words that are used on a daily basis in a court of law. So for that particular, for those quizzes, the antonyms and the synonyms, this is what you need to do. Get that list. You can create a flashcard, put the right word on one side, okay, the original word, and on the back put the synonym and what you think is the antonym, okay, or just the synonym, but study at least the synonym. And then just study them as the same way you study your legal terminology. You will know some of them. You will know the meaning of those words. You will see that sometimes you can even go to Google and type that, and it can give you examples and even synonyms of it, and even antonyms if you want to. But there is no need. You really should know what is the synonym of each of these words and also the antonym. Okay? But if you know the synonym in the exam, you can figure out the opposite. The antonym is the opposite. So you have to study all those. Once you study all that vocabulary, either using flashcards, sometimes writing will help. You need to take the quizzes, and please make sure that you do not jump from the quiz, let's say, on synonyms to the one on antonyms until you successfully complete that quiz. And successfully complete means that you score the required score that is indicated below the link, the button where you click to access the quiz. The interesting thing about the quiz, when you take the quiz, you're going to notice that the first time you take your quiz, which will be here on I believe, on sentence completion, you will have to register yourself. Put your, your name and username, and I guess it's a password, and so on and so forth. And when you do that, you submit and you take the quiz. The second time that you take the second quiz, you don't have to register again because you have two options on the quiz. So let me just show you what I'm talking about so that it is more clear to you. Okay, so let's see. Let me just bring the... So, let me see. When you go to your site, when you go to the site, the location where you have the preparation for the written exam, you will be able to see, you will be able to, when you click on quiz number, whatever quiz for sentence completion or synonyms or antonyms, once again, you're going to see that it has the following. It has, if this is the page, you're going to see that it has here the registration. It asks you for a lot of items, basic thing, and you submit. And you do that the first time. Of course, remember what your username and what your password is. When you go to the second quiz or any other quiz from now on that you take in this class, you can go directly to the left where they only ask you for the username, user's name,